On the day he died, Kenneth Lay was a convicted felon, 6 counts, a jury's unanimous word, a prison sentence waiting to be read. 14 weeks later, a federal judge wiped every count off the books. In the eyes of the law, the man who built the biggest corporate collapse of his era died an innocent man. Not pardoned. Not acquitted. Erased, as if the trial had never happened at all. To understand how, you have to go back to a company that an entire country believed in. Kenneth Lay was born poor, the son of a Baptist preacher in rural Missouri. He earned a doctorate in economics and carried something rarer than any degree, a preacher's gift for making people believe. In 1985 he merged 2 natural gas pipeline companies and named the result Enron. Within 15 years, it was no longer a pipeline company at all. Enron learned to trade energy the way Wall Street traded stocks, contracts, futures, bets on the price of things it never physically touched. It used an accounting method called mark-to-market, which let the company book years of projected future profit as income today, the moment a deal was signed. If the profit never actually arrived, that was tomorrow's problem. On paper, Enron looked like a machine that printed money. Fortune magazine named it the most innovative company in America 6 years running. The stock climbed past $90. Lay became a paper billionaire, a friend of presidents, his name bolted to a baseball stadium in Houston. And the people who worked for him believed most of all. They poured their retirement savings, their 401(k)s, into Enron stock, because the man at the top told them it was the safest bet in the building. That is the first thing the record shows about people. We do not follow numbers. We follow confidence. And Kenneth Lay radiated it. Inside Enron, doubt was not welcome. The culture prized winners and pushed out anyone who asked hard questions. Executives were ranked, and the bottom performers were culled every year. In a place like that, the pressure runs one direction: hit the number, book the profit, and never be the person in the room who says the emperor has no clothes. Fear does not just silence people. It teaches them to silence themselves. But the machine had a hidden room. His chief financial officer, Andrew Fastow, had built a web of partnerships with names like LJM, shell entities whose real purpose was to move Enron's debt and losses off its own books. Money that should have shown up as a loss disappeared into these structures. The profit stayed on the books. The debt vanished from them. For a while, it held. Then, in 2001, it stopped holding. In August, the chief executive, Jeffrey Skilling, abruptly resigned after only 6 months in the job. He gave no real reason. Kenneth Lay stepped back in to run the company he had founded, and told the world that everything was fine. It was not fine. In October, Enron disclosed a loss of more than $600 million and erased over $1 billion in shareholder value in a single announcement. The stock began to slide. And here is the detail the record nails in place: while it slid, Lay kept telling his own employees to buy. Weeks before the end, at company meetings, he called the stock an incredible bargain, and said his personal confidence had never been higher. What the employees didn't know was that Lay himself was selling more than $70 million of Enron stock, sold quietly back to the company that same year, to cover his own personal loans. On December 2, 2001, Enron filed for bankruptcy. At the time, it was the largest in American history. roughly 20,000 people lost their jobs. More than $1 billion in employee retirement savings simply evaporated. Arthur Andersen, one of the most trusted names in all of accounting, Enron's own auditor, was destroyed alongside it. The people who paid were not the executives. They were line workers, engineers, assistants, men and women in their 50s and 60s who had done exactly what they were told, and who watched a lifetime of savings vanish in a matter of weeks. Some had every dollar of their retirement in a single stock, because loyalty had been sold to them as prudence. When the giant fell, it did not land on the men who built it. It landed on them. And a country that had worshipped this company was left with a truth it hates to admit, that the smartest people in the room had either lied to everyone, or had believed their own lies so completely they never saw the edge coming. In January 2006, Kenneth Lay walked into a federal courtroom in Houston. Beside him sat Jeffrey Skilling. Between them, the two men faced dozens of counts: conspiracy, securities fraud, wire fraud. Judge Sim Lake presided. The trial ran nearly 4 months. The government's case had a spine, and its spine was Andrew Fastow. The CFO who had built the hidden partnerships had already pleaded guilty and agreed to cooperate. From the witness stand, he described the fraud as something the men at the top understood and blessed. He testified that he had stolen from the company and lied to it, and that Lay and Skilling knew the numbers were a fiction. For weeks, prosecutors walked the jury through the memos, the emails, the accounting. They argued that Lay had told the public one story while the internal numbers told another. The defense fired back that Fastow was a self-serving thief buying a lighter sentence with his testimony, and that a man cannot be guilty of a fraud his own CFO hid from him. The jury was left with one dead serious question: did the captain not know his ship was sinking, or did he know, and keep selling tickets? Lay's defense was not that the fraud never happened. It was that he never knew. He told the jury he had been betrayed by Fastow, blindsided, that Enron's collapse was a run on the bank, driven by short sellers and a hostile press, not by fraud at its core. On the stand, Lay was combative. He argued with the prosecutor. He bristled. He seemed genuinely offended that anyone could doubt his word. And that is the strangest thing the transcript preserves: a man who may have truly believed he had done nothing wrong, even as the record of what he told his own employees sat on the table in front of him. Because self-justification is not the same as lying. The most dangerous liar is often the one who has convinced himself first, and Kenneth Lay had spent his whole life being believed. On May 25, 2006, the jury returned guilty on all 6 counts. In a separate trial decided by the judge alone, Lay was convicted on 4 more counts of bank fraud tied to his personal loans. Skilling was convicted on 19. Kenneth Lay, 64 years old, now faced the real possibility of spending the rest of his life in prison. Sentencing was set for that autumn. He never heard the number. On July 5, 2006, just 6 weeks after the verdict, before a single day of his sentence had been handed down, Kenneth Lay died of a heart attack at his vacation home in Snowmass, Colorado. Coronary artery disease. He was 64 years old. And then the law did something almost no one outside a courtroom has ever heard of. There is a doctrine in the federal courts called abatement ab initio, Latin for, from the beginning. It holds that if a convicted defendant dies before he has had the chance to exhaust his appeal, the conviction is not merely paused. It is vacated. Erased. The indictment itself is dismissed, as though the case had never been brought at all. The logic is that a conviction is not truly final until the appeal has been heard, and a dead man can no longer appeal his own case. On October 17, 2006, Judge Sim Lake applied it. He vacated Kenneth Lay's conviction, all 10 counts, because Lay had died with his appeal still pending. Legally, the verdict evaporated. The man 12 jurors had unanimously found guilty was, once again, presumed innocent in the eyes of the law. For the families who had lost everything, it was almost too cruel to accept. The conviction they had waited years to see simply ceased to exist. And it carried a second, colder consequence. It complicated the government's effort to recover roughly $43 million from Lay's estate, because it is very hard to collect on a crime that, legally, never happened. The others were not so lucky. Fastow served his years and walked out. Skilling appealed all the way to the Supreme Court, which narrowed one legal theory used against him. He was later resentenced and finally released in 2019. The employees who had trusted the stock got back pennies on the dollar, if that. And Kenneth Lay, the man at the very top, the founder, the face on the stadium, carries no conviction at all. In the official record of the United States, he is not a felon. He is a defendant who died before the story was allowed to end. Enron became a word. It stopped being a company and became shorthand for corporate greed, hauled into Congress, stamped onto new laws, taught in business schools as the thing never to become. And in that transformation, Kenneth Lay stopped being a man and became a symbol. It is easier to hate a symbol. A symbol never has to be understood, only condemned. But the court does not deal in symbols. It deals in the timing of an appeal. So here is the question the record leaves in your hands. 12 people sat through 4 months of testimony and agreed, unanimously, that this man was guilty. A doctrine of law, triggered by nothing more than the timing of a heart attack, says that he was not. Which one is the truth, the verdict 12 human beings reached with their own eyes, or the technicality that quietly erased it? The court has its answer. It may not be the same as yours. Follow for more.